Hi there. Welcome and thank you for joining us today. The USC Family Caregiver Support Center is pleased to provide this educational video for families and relatives who want to learn more about legal and financial planning as they continue to take care of one or more loved ones. Today's topic will address estate planning and trust administration. I'm Jenny Peterson, and I'll be your host for today's program. I'm here today representing the USC Family Caregiver Support Center, which serves and supports family caregivers as they navigate through their caregiving journey. The center provides services such as information and referral, support groups, evidence-based trainings, community education, and much, much more to family caregivers seeking help. We like to think of ourselves as a valuable lifeline and important resource for family caregivers. Our center is also home to the Los Angeles Caregiver Resource Center, which is part of the California statewide system of 11 caregiver resource centers. If you happened upon this video by chance and you don't know about our center yet, please visit our website at www.fcsc.usc.edu for more information. Better yet, you can even sign up for our program right on our website through the yellow CareNav tab on the right-hand side of the page. We know that family caregivers need support, and our center is here for you. Now, today's presentation will focus on estate planning in a nutshell. And I know that many of you out there hear the words estate planning and you automatically think, well, I don't have an estate. Or maybe you're thinking, oh, only rich people have estates. And that's simply not true. If you have a banking account, if you have a retirement account, if you have any sort of financial assets, no matter how wealthy you are, everyone has an asset. And anyone who has an asset is considered to have an estate. Okay, it's not just for wealthy people. We will talk about how to plan for the future so that your or your loved one's estate is handled in a manner of your choosing rather than falling to probate court to decide the outcome. With us today is Monica Goyle from the prominent law firm TLD Law based in Long Beach. Besides being a USC alum, you know how we like to work with USC alums here, Ms. Goyle is an elder law attorney who is a certified specialist in estate planning, trust, and probate law. Monica, welcome. Take it away.
Hi there, everyone. My name is Monica Goyle. I am a partner and a certified legal specialist in estate planning, trust, and probate at TLD Law. I'm so excited to be with you to do this presentation and to give you all a little bit of a background and education on life and estate planning in a nutshell. Next slide, please. So people often ask me, what is an estate? And a lot of times people don't think of all of the individual components that go into making up an estate. We oftentimes think about maybe real property or our bank accounts, but really an estate encompasses so much more than that. It includes retirement and IRA accounts. It includes insurance policies, annuities, and it also includes considerable personal property, which oftentimes might be the least in value, but can be the biggest sticking point when it comes to settling an estate. It's also important to keep in mind that, especially now in the digital era, there are many digital assets that make up an estate, which include mutual funds, stocks, and also things like new technology like Bitcoin, where there may not be paper statements or paper stock certificates for anymore. So it's extremely important to be mindful of these extra technology assets that also help make up the estate, and to keep all of this in mind when we talk about estate planning and estate planning in a nutshell, what we're going to be talking about as we go forward in these slides. The next slide, please. As I was just saying, the estate plan components consider all of these assets that we're going to be considering and how to deal with them specifically in the estate plan. That includes also business interests. If you own or are part of a partnership or own an LLC, that includes any profit sharing plans, 401k. It also includes any stock plans or stock investments that you might have from your company. And as I touched on earlier, things like bank accounts, life insurance, and real estate, particularly your home. We always think of our home as our biggest asset that we want to protect when we're doing estate planning. Next slide, please. It's so important to plan, not only so that we can control who receives our assets, but so that we can also pay minimal legal fees and taxes. In California and in many states across the country, if you have no estate planning documents at all or only a will, your estate will go through probate administration, which is a very lengthy and costly court process. Whenever you hear the word court, you want to avoid it at all costs, specifically because of the high costs. But an important reason to plan is not only to worry about our estate going through probate after we pass, what kind of fees that might look like, or even taxes. A really important reason to plan is to plan for our own safety and health during our lifetime. People are living longer, but they're also facing different afflictions, which may affect their capacity during lifetime. And estate planning helps you manage your assets and your health in the event of incapacity. It allows you to appoint really important people that you trust to be able to help manage your finances and your healthcare decisions during your lifetime. So, why do we plan? We plan not only for what happens after we pass away, because we certainly don't want the state to control that. It's also important to plan so that we can help control and manage our own health during our lifetime in the event of incapacity. Next slide, please. So let's talk about common estate plans. And I'm going to go into each of these very specifically so that we can talk about the pros and cons and we can understand what they are. But in general, here's a list of what I often see. Sometimes people do nothing at all. Some people own a will. Some people try to avert having to do any planning by doing joint ownership, by putting title in the name of their loved ones. And we're going to talk about that and what that looks like and the pros and cons of doing that. Some people simply gift or give their assets away during their lifetime. Some people list or depend on beneficiary designations on their accounts. They're often called pay on death accounts or TOD accounts. But the more superior way of planning is to do a revocable living trust. And we'll talk about that in detail and what those components look like. Next slide, please. So, plan number one, what is a will? I think a lot of times we have a basic understanding of a will because we often see it on TV. Sometimes it's full of drama. They show in the movies and television shows a will reading where everyone gathers around in a very dramatic way and someone reads out the will. That doesn't actually happen in real life. We don't read a will, but we do provide notice and lodge an original will with the court and provide notice to all of the heirs of the will. A will is a document in writing that sets forth what you would like to happen with your assets when you pass away. It only controls assets that are in your name. And the only way that a will is enforced is through the probate court. So, as I mentioned, if you have no documents at all or only a will, you're going to end up having your estate go through the probate court in order for it to get to your loved ones. So, while a will is important and can be very effective in expressing your wishes on death, on where you want your assets to go on death, unfortunately, it still needs to go through a very lengthy and expensive court process. So, a will is not particularly the best type of planning. A will also only sets forth what happens when you pass away. It provides you no comfort, no appointments, no ability to help anyone control you or your assets or your health care in the event of incapacity. So it purely states your wishes on death. Next slide, please. So these are the important things to remember. The will is no help during incapacity. It has to go through the court process, which is expensive and time consuming. It's also very public. As I mentioned, the will gets lodged in the court and becomes a public document. And it does not serve as any durable power of attorney or anything during your lifetime. Next slide, please. A durable power of attorney is a document that helps you in the event of incapacity. It appoints an agent to stand in your shoes and handle your finances. That includes something as simple as bill payment. It also includes paying your taxes or signing your tax return, dealing with medical insurance claims, and dealing with Social Security. So, a durable power of attorney is a very important and useful document that can be used during your lifetime to appoint someone to manage your finances in the event of incapacity. Next slide, please. An advanced healthcare directive is likewise an extremely important document that comes into place in the event of incapacity. A healthcare directive allows you to appoint the agents that you wish to be able to access your medical records, make medical decisions in the event that you're unable to do that for yourself, and make end of life decisions, including, for instance, when it's appropriate to remove the life support. It's extremely important because so many Americans think that their next of kin, their loved ones, can make these important decisions for them. But sometimes our loved ones clash, and the laws have changed to very specifically require not only an advanced healthcare directive, but an advanced healthcare directive that contains very specific language, often called HIPAA, if you've heard of HIPAA. But the Healthcare Privacy Act has come into place, which requires that you give very specific written authority to people to be able to access your medical records and to make end of life decisions. So it's extremely important that not only do you talk about these things during your lifetime with your loved ones or your agents whom you trust, but it's so important to put these things in writing with an advanced healthcare directive. And I have to say, it's not just for the elderly. It's extremely important even for college students, for instance, leaving home. If you have a college kid leaving home, remember, now that your child is 18, they are no longer a minor. You're no longer their guardian. You will not have access to their medical records or ability to make medical decisions for them unless they've signed a healthcare directive that contains a HIPAA release, which again is under the Healthcare Privacy Act to be able to authorize to access medical records. So important to have this type of estate planning document in place. Next slide, please. Unfortunately, most people, if they have no will or something in writing, they do nothing at all. And it's so unfortunate because they generally do this because they don't have an understanding of what will happen to their assets upon their passing. They believe, unfortunately, that the assets will pass naturally to their children. And while that might be the case, it's determined by the court where the assets get distributed according to state law if you have nothing at all. It says basically that if you've died intestate, which means without any testamentary documents, the state will decide where your assets go. And so at death, your assets go through probate administration, and the courts will decide where those assets go. So, for instance, if you wanted it to go to a beloved sibling or friend or charity, the court is not going to understand or recognize those things, especially because you're no longer with us to express that intent. The court has a very specific rule of law that they have to follow, set forth by the state, where the assets would first go to your children and spouse if you had child and spouse. And if not, it goes upward in your family tree. So then it would go to your parents. If your parents aren't living, it would go to your siblings equally. If you have a deceased sibling, their share would go to their children and so forth down the tree. So you may be finding that your assets go to family members that you never intended for them to go. Further, if you do nothing and you find yourself incapacitated, your loved ones will have to go to court in order to declare you incapacitated and to be able to have control and step into your shoes in order to do a conservatorship or some other type of court hearing, oftentimes similar to a guardianship, in order to be able to step into your shoes for your health decisions and your financial decisions. Next slide, please. Plan number 3. Oftentimes people think they can avoid planning or spending money on legal fees by using joint tenancy. Joint tenancy is a legal term that allows you to put assets, or to hold them jointly, I should say, with what's called right of survivorship. That means if 2 or more people hold assets together in joint tenancy, the survivor takes all without it having to go to the probate court. So, on the one hand, this might even be better than a will or having nothing at all, because you'll recall I said if you have no documents at all or only a will, it goes through the probate court. With joint tenancy, you can avoid probate, but it really only postpones the probate process, because when the second person passes and they have no documents, then it still goes through probate court. So joint tenancy might avoid probate on the death of the first person, or the co-owner, I should say, but it won't avoid probate altogether. It also does nothing to help you with incapacity. And it can oftentimes result in unintentional disinheriting. For instance, I have family members or parents who put the house in joint tenancy with one child, expecting that child to share with their siblings. And once that child inherits through right of survivorship, they don't have any intention to share at all. And under the law, they're not required to do so. The second thing, which is even more important, is that there are no takebacks when you gift or add someone to the title of your property. You cannot take it back if you change your mind. So I have parents who put a child on the property and they wish to remove them years later, and the child does not cooperate in doing so. There are no takebacks. There's no legal way for me to just remove them from the property. And it can be extremely problematic. If that child is going through a divorce, your property could be dragged through that same divorce. If your child were to inadvertently get into a car accident and get into a terrible lawsuit, their judgment creditors could come after your property. Likewise, if they had any other debts or tax problems, it could attach to your property. So be very, very careful about putting a property into joint tenancy. While it might avoid probate for a short time, it's not a very good long-term solution and can subject you to more hurt than benefits. Next slide, please. Plan 4. Unfortunately, some people just give their assets away during their lifetime, thinking that this will solve any and all problems. Next slide, please. Actually, could you go back for me, please? I'll stick with that slide. Let's talk a little bit more about giving away your assets. The most important problem is that you lose control over the assets. Once you've gifted them away, again, it's extremely important to understand here that there are no takebacks. Once you put the property in someone else's name and take it out of your own name, you have no legal authority or ability to take that property back unless the person cooperates in transferring it back. And it comes with all of the same problems I just mentioned, along with joint tenancy. If you give your asset away, that person now has control. Assuming that they were a good child, they may have a spouse that's not so good and forces you to move out of your own property or to lose control of your property. Even worse, again, if that child went through a divorce, that property would be subject to a divorce or judgment creditors. I do not recommend giving away your assets during your lifetime. It's even more problematic now with the changes in the laws. In California, you used to be able to transfer property between parent and child without any reassessment of property taxes. In November 2020, Proposition 19 passed, and that proposition took away the parent-child exclusion. So now, if you gift or transfer the property to your child, it will get reassessed for property tax purposes. Next slide, please. Plan number 5 is beneficiary transfer. So a lot of people try to avoid doing any advanced estate planning by listing a pay on death beneficiary on their assets. That includes bank accounts, IRAs, 401ks, and this is a good type of planning when it comes to IRAs and 401ks. 401k IRA plans are not ones that you want to put into a trust or do more advanced planning on, because these are income tax deferred assets that are accruing, which allow you to list a beneficiary And those beneficiaries are able on death to transfer or to roll them over. But with bank accounts, it can be particularly problematic because you might inadvertently disinherit someone that you don't intend to disinherit. You cannot list a minor as a pay on death beneficiary. They're not able to take that asset. In fact, if you list a minor, it could be so problematic that someone is forced to open a legal guardianship and put those monies into a blocked account. It also does nothing to help you for incapacity. So if you list a pay on death beneficiary on an account, that person cannot access the account during your lifetime or assist you with incapacity. Next slide, please. The far superior way of estate planning is to do a revocable living trust. A revocable living trust is a document that sets forth in writing where your assets go when you pass away, but it's so much more powerful than that. It allows you to also plan for incapacity. It avoids probate completely at death. It allows your trustee to immediately transfer assets to your beneficiaries. It allows that same trustee to be able to take care of you in the event of incapacity because you are first and foremost the trust. You own the trust, all of the assets are for your benefit. It provides the maximum privacy. This document is not lodged with the court and it does not become a public document. It allows for quick distribution to your beneficiaries. And more powerfully, the assets can stay in the trust for a variety of reasons. If you have an incapacitated child, you can set up a special needs trust for them. You don't have to disinherit them in order to make them still eligible for their benefits. You can give them a portion of your trust, have it held in trust to supplement their needs, and it will not result in any disqualification of their benefits. It also allows you to do the maximum estate tax planning, and we'll talk a little bit more about that before I conclude my presentation. But there's so many powerful ways to hold the assets in trust. You can hold the assets in trust to give a legacy trust to your children in order to prevent them from commingling it into community property when they inherit. It gives them creditor protection in the event that you do that. You can protect a child that's simply not good with spending money or might have addiction or drug problems. You don't have to disinherit them in order to allow them to benefit from your assets. You can also set up a pet trust if you have beloved pets that you wish to take care of on death, and it allows you to do quite a bit of charitable planning as well. Next slide, please. This is such an important slide that I want to share with you all so that you understand the cost of probate and statutory fees. On just a minimal estate, you'll see that the statutory fees are quite extensive. And if you get to an estate that's less than $1 million, but around 800,000, the statutory fees to the attorney are almost $19,000. Plus, the executor who acts to handle the estate also gets another $16,000. That's almost $35,000 in fees before your loved ones can even receive their assets. This makes probate administration such a costly process and a very public process. Remember, all of the documents are public and the will gets lodged with the court. A trust is a completely private document that does not get shared with the public. Next slide, please. The most important thing to understand with estate planning in general and doing a trust is that you keep control of your assets, but you get to gift them to your loved ones in the most efficient way possible. You can buy, sell assets as you did before because you are the trust. You own the trust. You file your taxes the same way as you do now. All assets stay under your Social Security number. A trust is revocable, which means that it's amendable. It can be changed or canceled at any time. As relationships change, as people change, as you go through different phases in life, you can amend the trust to change with your lifestyle. The trust contains your instructions on what you want to happen. If you don't want a piece of property to be sold for a certain amount of time, you can control that within the trust. If you want to control or meter out a distribution over a beneficiary's lifetime, you can do that. If you want to make it where the beneficiary never has direct access to the assets and that it's always held in trust, you can do that. The trust gives you so much control over your assets. And that's so important because these are assets that you've worked your entire lifetime to build. You've built this wealth and you have the right to determine where it goes upon your passing. You also have the right to live with respect and dignity so that someone can manage those assets on your behalf in the event of incapacity. Next slide, please. I've come up with a 6-step plan of action so that you can determine what type of estate planning and how to go about starting estate planning. Because I think part of the problem is that it's very hard to tackle these types of issues. It's hard for couples to sit down and talk about who should control our assets when we pass away. Who should be the guardian of our child when we pass away? And these are important things to talk about, but they can oftentimes be difficult things to talk about. So, if we implement a 6-step plan of action, it makes it a little bit easier to tackle these things. One, start with an inventory of all of your assets and your debts so that you have a basic idea of what your net worth is so that an attorney can help you decide if there's any estate tax liability. The inventory of assets will also make it easier for you to make sure that you touch on each of the assets that you need to fund into the trust. Funding of the trust is so important because the trust can be like an empty fishbowl. If you don't actually put assets inside the trust, it doesn't control what happens after you pass away. If the assets sit still in your name without changing title to the trust, you're still looking at a probate. So it's very important to make an inventory of the assets and ultimately make a game plan on how you're going to fund those assets. Step number 2, write down your objectives, your goals for before and after you pass away so that you have an understanding of how you want to be taken care of in the event of incapacity and where you want those assets to go when you pass away. This is an important step because, as I mentioned, sometimes a sticking block can be, for instance, who should be the guardian of our minor children. And oftentimes a couple might fight over whose sibling it should be or whose family member it should be. But if you come up with the list of your goals, it might make it easier to come up with a game plan on who would be the best person to take the child into their home and who would be the best person to manage the assets on behalf of the child. And in doing so, you can even come up with a very good balancing system so that there's checks and balances, so that whoever is taking care of the child has to work with someone else managing the finances, and they work together to check on each other and work in the best benefit of the child. Step number 3, select a professional to help you work through all of these issues. You don't have to know the answer to all of them, but it's important to start writing them down so that you can express your goals and a professional can help you put those goals to life into a document. Then don't hesitate to have those legal documents prepared. Don't try to avoid doing estate planning by engaging in any of those other types of estate plans we talk about. Do not do nothing. Do not attempt to circumvent estate planning by putting the assets in joint tenancy or gifting them away. There are so many cons involved. Whereas with the trust, the only con might be the time and the cost in assembling the documents, but the cost of the document will not rival anywhere near the probate fees and the statutory fees that we just saw on that spreadsheet that I showed you. And so make sure to have the legal documents prepared. Then be sure to put that plan into action. Make sure you talk through with the attorney how you're going to fund the trust, and make sure you also set up with the attorney a schedule to review and change the document as needed. Remember, your life changes, relationships change. It's important that the estate planning documents grow with you and that you're able to make changes and let your own goals and wishes come to fruition as those relationships change. Next slide, please. It's really important to talk through what type of wealth transfer strategy is right for you. That's why the 6-step plan is so important. We need to make sure that we understand the value of your estate so that we understand whether or not you have a taxable estate. We need to understand the type of assets you have so that we can determine how best to protect you from liability going forward. It's important to understand your cash flow needs. That way, a professional can help assess whether or not you have any income tax liability, how to reduce that liability, and whether gifting might be appropriate to help reduce your assets and your estate tax liability. And then it's really important to determine who in the next generation are the people that you want to receive your assets and who might be the best people to help you manage or control those assets as the trustee. Next slide, please. Some really important wealth transfer techniques, some more advanced techniques, include setting up a marital trust with an A-B split. If you have a taxable estate, this type of marital trust allows you to double the exemption amount upon the death of the first spouse. This type of technique can also be utilized and implemented when you have a blended family. The reason for that is because in an AB trust, half of the trust becomes irrevocable on the death of the first spouse. While this might not be needed for estate tax purposes in order to double the exemption amount, it can still be very useful in blended families to allow families to have half of the trust become irrevocable so that their children from prior relationships do not get disinherited by their surviving spouse. It's also important to determine and to discuss with your attorney annual exclusion gifts, the total amount of gifts that you can give to your loved ones or family members without having to report them to the IRS. Another useful technique is 529 college saving plans because they are taxed at a different rate and might be able to help reduce your income tax liability and capital gains tax liability when you utilize those funds for education. And lastly, it's really important to look at insurance and how insurance can help you plan. As the exemption might go down, I mean, we're right now at a place in 2021 where the exemption is very high. It's over $11 million. But in the future, it might come down to a level where it might be in the 5 million range or lower. And so we might be utilizing techniques like life insurance trusts or ILITs in order to avoid estate tax liability. Next slide, please. Some really important wealth techniques as we deal with larger estates and dealing with liability is to determine what amount of gifting might be appropriate. Now, you might recall at the beginning of the presentation, I said that gifting was not a good type of estate plan. And it's not a good type of estate plan if that's the only type of estate planning you're doing. This type of gifting that I'm referring to is gifting specific assets in your estate that you can currently live without while the gift exemption is quite high in order to reduce your taxable estate on death. So for instance, if you have a child that works with you in your family business, and the business is generating more income than you currently need, but is going to continue to grow in value, a value so high that it might make you have a taxable estate on your death, you might want to consider gifting the business to your child during your lifetime and all the income that goes with it in order to not only reduce your income tax, but to reduce your taxable estate at death. This type of gifting can also lead to discounted valuations for the business, which can help control really high valuations of business that might make your estate subject to estate tax. We can also consider what type of entity would be appropriate. Family limited partnerships and limited liability companies are really important ways to be able to, one, in terms of companies or setting up corporations, create some kind of asset protection. Now, I've said a lot of wonderful things about estate planning and trusts, but trusts do not give you asset protection because you are the trust. You can still file your taxes as you do now and you still own the assets. But forming a limited liability company, an LLC, can give you asset protection. So if you put a piece of property into an LLC, you can manage or control the liability on that property so that if a lawsuit arises, it does not touch your personal assets. So doing estate planning and forming a trust in conjunction with an LLC can be a really important wealth transfer technique and estate planning tool that can help reduce your probate fees, taxes, and your liability. Next slide, please. I want to thank you all so much for sticking with me through this presentation. I hope you've learned quite a lot about estate planning and why it's so important to tackle that estate plan. Please be sure to follow the 6 plan steps and find a professional that can assist you with all of your estate planning needs. Thank you so much.
Thank you, Monica, for that informative presentation. One of the most important things I learned from you today is that hope is not a plan. Many of us hesitate to talk about these topics because we might feel like it's taboo, or we're tempting fate by talking about these things when we're perfectly fine. We have no health conditions, right? Or maybe there's nothing to worry about just yet. The truth is, that's exactly why we need to discuss these topics at this moment in time, right now, because we are, in fact, well and of sound body and mind. If we wait too long to put some of these legal plans in place, we may find that the opportunity to do so has passed us by. Thank you today for joining me as we learned about estate planning. And a very heartfelt thank you to Monica Goyle for her wonderful presentation. As I mentioned at the beginning of this video, the USC Family Caregiver Support Center is here to educate you, connect you to resources, and support you throughout your caregiving journey. Please be sure to visit us at www.fcsc.usc.edu or visit our social media pages on Facebook, Twitter, and Instagram to learn more and connect with our center. If you enjoyed this video and found it helpful, please do us a favor and click like below the video. Also, make sure to click on the red subscribe button, also below, to subscribe to our YouTube channel and be notified every time we post a new educational video for the caregiving community. Take good care of yourself, and until next time, just remember that caregivers fight on.